Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those who are here early, thank you for waiting patiently. While you are waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk on adopting children in Malaysia. My name is Chiu, and I'm a paralegal with Ma Wing Kwai and Associates. I will be the moderator for today's sessions. Before we start today's session, allow me to introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today consists of 23 lawyers and a support team of 19. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment department, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. We have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But due to the COVID-19 Movement Control Order, or MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. This is the 33rd talk in our MWKA online talk series. Please feel free to visit our website at mawingkwai.com for more information, to read our articles, and sign up for more upcoming talks. Our upcoming talk will be on immigration-related offenses in Malaysia. Before I continue, please be reminded that this talk does not constitute a legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce both our speakers for today. Firstly, we have Ms. Jasmine Wong. Jasmine began her practice in Wong and Associates as an associate in 2017 upon her admission to the Malaysian bar. Jasmine's primary areas of practice include general litigation, particularly in citizenship, adoption, medical, and employment law. Next, we have Mr. Eric To. He began his practice in Wong and Associates as an associate in 2018 upon his admission to the Malaysian bar. Eric's primary areas of practice include general litigation, particularly in family, citizenship, adoption, defamation, and land. Our speakers hope to complete today's talk by 3:45 p.m. and thereafter proceed with the Q&A session. So if you have any questions, please don't forget to post them up on Slido and our speakers will address them later. You should have received a link to Slido during registration, but I will leave this slide up for a while so that you can scan the QR code before we move on. Alternatively, you can go to Slido's page and key in the code 41044. I repeat, 41044. Here are our top points for today. During this talk, Ms. Jasmine and Mr. Eric will provide us with an overview of the Adoption Act 1952 and the Registration of Adoptions Act 1952. Later, they will explain the differences between court and departmental adoptions, and also what to consider and how to prepare for adoptions. With that said, I will now invite Jasmine to share her insights. Over to you, Jasmine.
Thank you, Chiu. Hi, everyone. I will begin with the Adoption Act, and Eric later on will explain the procedure concerning the Registration of Adoptions Act. As you may know, there are two different ways to adopt a child in Malaysia, one of which is an application to court under the Adoption Act. The proceedings, which would take an average completion of about 6 to 9 months, would include at least 2 court hearings and a home visit conducted by the welfare officer. If there are no complications throughout the proceedings, and depending on the court schedule as well, the adoption application can be completed as fast as 4 months. But in the current unprecedented times, such as during the COVID-19 pandemic and the MCO situation, what we are seeing is that court matters are currently being postponed. And even when the court reopens, there are lesser cases being fixed in a day. This is to ensure that there are lesser people in the courtroom at one time. So bearing this in mind, this may prolong the proceedings further. The adoption proceedings will commence the moment you file your originating summons, the affidavit in support, and the adoption statement. Throughout these proceedings, all parties, namely the adoptive parents, the child, and the biological parents, are required to attend all the scheduled court hearings. An exception to this compulsory attendance is if the judge exempts the biological parents or the child from attending the court hearing. So what happens after you have filed your adoption paper in court? The first hearing is the interim hearing. All hearings for adoption proceedings are conducted in chambers. During this interim hearing, the judge will confirm the identity of all parties. The judge will also peruse the course papers and ask any necessary questions and grant the interim order. During this interim hearing as well, the judge may strike a conversation with the adoptive parents or the child. During this interim hearing, the judge may also give the necessary orders, such as the appointment of the welfare officer as the guardian ad litem, the dispensation of consent, or the attendance of the biological parents. So what happens if the child does not know that he or she is adopted, or if that the child have always been under the impression that his adoptive parents are his biological parents? What we would have done is we would inform the judge about this situation, and the judge would direct the child to wait outside of the chambers. In such a situation as well, the child's attendance in court would be exempted during the next hearing. This is also in line with the spirit and intention of the Adoption Act, wherein the Parliament wants to prevent the possibility that the knowledge of the child being adopted would have any psychological effect on the adopted child. The child also may be unprepared to learn of its actual background status. So to prevent such a situation, we do not actually disclose the fact that the child has already been adopted. So who is the guardian ad litem? The welfare officer is appointed as the guardian ad litem during the interim hearing. His or her duties is to ensure that the child is not in a detrimental or unsatisfactory environment. So the duties of a guardian ad litem is to investigate all circumstances of the child, whether the consent was duly obtained from the biological parents, whether any payment or reward in consideration of the adoption has been received or agreed upon, whether the applicants, being the adoptive parents, have the means and status to maintain and bring up the child, and whether, most important of all, whether this adoption is in the child's welfare interests. A lot of applicants or adoptive parents have the misconception that when the welfare officer is appointed as the guardian ad litem, the child will be brought into the custody of the guardian ad litem. But that is not the case. The welfare officer needs to be appointed as a guardian ad litem so that the officer can conduct a house visit and interview. The house visit will be conducted at the applicant's home. Such questions will be asked by the welfare officer concerning the child's education, child's activities in school, the child's hobbies, and details about the adoptive parents' occupation and financial standing, and the adoptive parents' future plans for the child. The welfare officer would also be given approximately 3 months, give or take, to conduct the home visit and interview, and also to prepare a guardian ad litem report. This report will need to be given to the judge during the final adoption hearing. If the welfare officer is in favor of the adoption application, the judge will then endorse the guardian ad litem report and grant the adoption order. Once you have obtained the adoption order, you will need to submit the adoption order to JPN and surrender the original birth certificate to JPN. JPN will then reissue a new birth certificate with the name of the adoptive parents as the child parents. Do take note that there is no indication of adoption or the child being adopted on the new birth certificate. This is an amendment made in 2001, where prior to 2001, there was the word anak angkat on the birth certificate, but that is no longer the case now. I'll pass it on to Eric, who talk about the Registration of Adoptions Act 1952.
Thank you, Jasmine. Good afternoon, everyone. Just let me share my screen. Okay, so now I'm going to talk about an overview of the Registration of Adoptions Act. So what is the difference between or what I'll call RAA and the Adoptions Act, the AA? So the RAA is commonly known as departmental adoption because you don't go to the court to adopt a child, you go to the National Registration Department, the NRD. So, and one of the big differences for RAA as compared to AA is that it allows Muslims and non-Muslims to legally adopt children. Because under the Adoption Act, Muslims cannot adopt a child under the Adoption Act. So what you do under the RAA is you make an application to the NRD, National Registration Department, nearest to where the adoptive parents' place of residence, where they stay. So this is just another excerpt on why RAA is for use of Muslims and solely and not restricted to non-Muslims. So the rationale of the RAA and adoptions under RAA is so that it is an open adoption. A child would keep the original identity and the identity of the birth parents on record to be disclosed to the child at a suitable age. And the purpose of this is so that an adopted child does not enter into a non-permissible relationship, especially for Muslims, with blood relatives. And this is an important reason why the RAA is in existence. So what are the requirements to adopt a child under the RAA? Number one, the child must be unmarried and below 18 years old. The applicants must be ordinarily resident in Peninsular Malaysia or West Malaysia. And then you have to get consent from the parents or the guardian of the child if the parents are dead or if neither of the parents is within West Malaysia. But of course, consent can be dispensed with by the registrar of adoption if he or she feels that it is just and equitable in the circumstances of the case and for the welfare of the child. So it's not always that you need to get consent of the parents or the guardians. There are exceptions to that. So what are other requirements? The child must be brought up, maintained, and educated by the applicants for a period of not less than 2 years. So that's important. You must have custody of the child, maintain the child for at least 2 years prior to making the application to the NRD. And how do you prove 2 years? You can't just go up and tell the registrar, oh yeah, this child's been with me for 2 years. So what you should do, when you first get custody of the child, maybe you get a consent letter or the statutory declaration or SD by the birth parents during the handover of the child to you. So to show that the child has been given, the custody has been given over to you. And so the 2 year period starts from the date of handover and not the date the SD was affirmed. And once you register the child, the adoptive parents will pay a small fee of 30 ringgit, and the child's original birth certificate will be surrendered to the National Registration Department. So what do you have? You may ask. Then the NRD will in turn issue the child with a certificate of adoption. And what you can use the certificate of adoption is same as the birth certificate. Use it for school registration, apply IC, passport, and other official transactions. But that's just something to take note. So this is an example of a certificate of adoption. So you see that it says daftar anak angkat, place of birth, etc., name. So this is what you will get when you adopt a child under the RAA. Okay, now I will talk about the differences between a court adoption under the Adoption Act, as explained by Jasmine earlier, and a departmental adoption under the RAA. So as I mentioned earlier, AA is only for non-Muslims, while the RAA is applicable for Muslims and non-Muslims. And the RAA also requires the child to be raised and maintained by the adoptive parents for 2 years prior to the application for adoption. The Adoption Act does not have this requirement. So basically, once you have custody of the child, rather immediately, maybe a couple of weeks or within a month, you can make the adoption application to court if you wish. The adoptive parents under the Adoption Act will be known as parents, while under the RAA, the adoptive parents will be legally more known as the foster parents, ibu bapa angkat. And of course, the child under the AA will receive a new birth certificate, whereas a child adopted under the RAA, as I mentioned, will only have a certificate of adoption and not a new birth certificate. So there are also different rights when you adopt a child under the AA as opposed to the RAA. So rights as listed in the slide, you have to future custody, maintenance, education, appointment of a guardian, consent to a marriage, and inheritance if the adoptive parents die in their state. Because if you're adopted under the Adoption Act, if a parent died in that state, then the adoptive child will be deemed as the child of the parent when distribution of assets is considered. So is adoptions final under the AA or the RAA? Yes. Adoption under AA is final. Adoption under the RAA is also final. But however, there is a section in the RAA, section 13, which allows for the cancellation of the registration of adoption under certain circumstances. But in all purposes, basically adoptions under either act are final. Okay, so I'll pass it back to Chiu to continue on to our next session.
We will now proceed to our FAQ session. In this session, our speakers will address the frequently asked questions on adoption. So the first question, Jasmine, how can I locate a child to be adopted?
This is a very common question that we usually get from parents. Usually, you can, through word of mouth from friends, acquaintance, and neighbors, or you can also inquire at the NGOs. The frequent and common NGOs would be Yayasan Child Kid, Orphan Care, and also at JKM. But what you will actually encounter is there is a long waiting list. And if it is your turn, they would take some time to vet you and to see if you are a suitable applicant. And they will reach out to you if there is any suitable child that matches your profile.
So if I have identified a child, what should I proceed to do next?
Well, first of all, you need to make sure that the child has a birth certificate. If the child does not have a birth certificate, you will need to apply for one at the NRD. If the child was just born, the birth registration needs to be done within 60 days. If you have exceeded the 60 days, that will be considered as late registration. And that is a more tedious process because that will include interview. You will need to produce witnesses who know about the child's birth. And the NRD would, the investigation unit in NRD will need to inspect and check and verify concerning the child's birth. Once that is done, then the child will be issued with a birth certificate. We have previously tried to adopt a child without a birth certificate because the Act actually does not specify so, but we have received objections from the welfare officer. And because of that, what any parent will need to do is to get a birth certificate register the birth and get a birth certificate from the NRD first. Once you have gotten that, the next step would be to obtain the consent from the birth parents or the birth mother. And this will be done via the signing of a statutory declaration. And the next step would be for you to consult a lawyer because the lawyer would be able to advise you on the filing of the adoption proceedings in court.
So Jasmine, who do you think can apply for adoption?
These are all statutory requirements provided under the Act. The adoptive parents will need to be ordinary resident in West Malaysia. The applicants cannot be Muslims as well, or anyone who professes the religion of Islam. If they are not related to the child, there must be at least 25 years age gap, or at least 21 years older than the child. And a child is defined as a person who is unmarried and below 21 years old. This is contrary to the Registration of Adoptions Act, where the child is, the age limit of the child is 18 years old. And also there is no age limit if the applicant is the biological parents, biological mother or father of the child.
So Eric, can you please explain the parties involved in adoption?
Thank you, Chu. Simple. The applicants would be the adoptive father or the mother, those that want to adopt. And the respondent is usually the Jabatan Kebajikan Masyarakat, Welfare Department, the child, of course, and the child's biological parents, if you can locate them. Sometimes we have issues with locating a biological parent. We don't know who they are. So then they won't be listed as a party. But if you know the mother, at least then she should be listed as a party.
So if I'm single, is it possible for me to adopt?
Well, if you are female, then yes, no issues. We have helped single female applicants before, so you don't have to be married or anything. If you are a male, a single male, and you are trying to adopt a female child, then the court must be satisfied that there are special circumstances for you to do so. And this is, I think, logically for the protection of a female child if adopted by a male adult. So I think perhaps one of the special circumstances would be if you are related. So then the court might deem that to be a more suitable case if you are a single male and the child is a female.
So if I am a Muslim, is it possible for me to adopt a child?
No. So as explained earlier, you have to adopt under the RAA, which is you have to go to the JPN to make the adoption application and not through the courts.
Jasmine, if I would like to adopt a child from Sabah and Sarawak, is it possible?
Yes, it's possible if the child comes to West Malaysia subsequently and the child is staying and is an ordinary resident in Peninsular Malaysia. But if the child is actually staying in Sabah and Sarawak, then no, because there's a different adoption ordinance to be applied in Sabah and Sarawak there.
But if I adopted a child overseas, will I need to adopt him again in Malaysia?
This will need to depend on the circumstances, because if you are referring to an adoptive parents who are foreigners and you are staying in Malaysia, then it is not required for the foreign parents to adopt the child in Malaysia. But if you are in a situation where you are a Malaysian citizen and you have adopted a child overseas, and then you subsequently bring the child back to Malaysia, we advise for you to adopt the child, because then you will be able to secure both your rights as the parents and your child's rights under the laws of Malaysia.
So Jasmine, what documents will I require for such a procedure?
This would be the basic required documents, such as the child's birth certificate, the applicant's, meaning the adoptive parents' IC or passport and marriage certificate, employment contract and salary slips to show your financial standing. You will need to give and produce your bank statement as well. So we usually have got a question whether we actually need to be rich to adopt a child. The answer would be, it's hard to quantify rich. So if you show that you have the sufficient means to raise the child, then it should not be an issue. You will need to produce a copy of a tenancy agreement or your house title, details of the child's biological parents, and the consent letter in the form of statutory declaration. And if the child is already schooling, you will need to produce the information about where the child is schooling currently and at what level of education, and also photographs of the child with the applicants.
So where can I file such an application?
You can file it in the state where you are residing, where the adoptive parents are residing, because then that is where the home visit will actually be conducted by the welfare officer. This is also, in terms of which court you'll be filing, this is stated under Section 10 of the Adoption Act 1952, where the court recognized that the High Court has the jurisdiction to hear adoption application. But in practice, usually adoption applications are filed in the Sessions Court.
So in such adoption application and proceedings, what are the usual complications that I might face?
Yeah, so these are the usual circumstances, the usual problems that adoptive parents face. Number one, you cannot find the biological parents. Number two, you found them, but they don't want to get involved in the court proceedings. Or number three, they don't want to consent, they refuse to consent, even though it's clear that they are neglecting the child. So the answer to that is you have to apply to dispense with their consent. So you apply to court, there's what we call dispensation application, so that you don't have to get them to attend court, you don't have to find them, or if they refuse consent, even though they are clearly neglecting the child, then you have to find proof to show why they are neglecting the child. So if you, maybe when you have custody of the child, then you realize that the child is in very bad health, malnourished, or if the child is already of schooling age, they are not even in school, they can't read or write, and so those are maybe the grounds for you to delve deeper and say, look, these parents are neglecting the child. It's not in the child's best interest to continue staying with these parents. So you can apply to dispense with the parents' consent in those circumstances as well. So, and one way, I think if we move to the next slide. So one way, if you cannot find the biological parents, but you want to dispense with their consent, is you make this advertisement in a local newspaper. So because simple, because you shouldn't put the name of the child in the advertisement. That is not allowed under the Adoption Act. So you just say a child has been abandoned on this date and this place. And if anyone who has the information on the identity of this child, please contact the lawyers. In this case, it was Jasmine at our firm. So with that, that would usually suffice for the court and the welfare officer to say, okay, we can dispense with the attendance of the biological parents.
So does this mean my child will be a Malaysian after such an adoption?
No, unfortunately, the laws of Malaysia as to citizenship after adoption is still quite restrictive, if I may put it that way. So if the biological mother is not a citizen or her identity is unknown, the courts and indeed JPN will still not grant the child Malaysian citizenship. So, well, you can refer to another talk given by Jasmine and I previously called Citizenship for Adopted Children and Stateless Individuals. You can find it on YouTube. I'm going to click on the link there as well. So then we'll have a much more detailed explanation as to the process for getting citizenship for a child after adoption. But for this current question, the short answer will be no, unfortunately. And this is just an example of the birth certificates that a child would get after adoption if the child's biological mother is not a Malaysian citizen. So you get the pink color Bukan Warga Negara birth certificate, whereas Malaysian citizens will get the green color birth certificate.
Thank you, Jasmine and Eric, for sharing with us. We will now take questions that some of you have posted on Slido. Remember, you can ask us questions on Slido either by going to Slido's webpage and keying in the code 41044. I repeat, 41044. We have quite a few questions today. So the first question is, are spouses who are not Malaysian citizens or PR allowed to adopt along with their Malaysian spouse? Some agencies insist foreign spouse must be a PR.
Well, the answer is yes. There is no restriction or requirement under the Adoption Act for the foreign spouse to be a PR. They simply need to show a valid passport, and anyone can apply to adopt a child under the Act if provided they satisfy the ordinary resident requirement in Malaysia.
Okay, the next question. Do the adoptive parents get a formal legal document to say that the child is adopted in the case parents would like to go overseas with the child for a few years?
Yeah, I'll take that. So yes, you do get a formal legal document in the sense that if I understand the question correctly, so if you adopt under the Adoption Act, number one, you'll get a court order saying that you have officially and legally adopted the child, and then you will get the fresh birth certificate, which puts your name as the child's father or mother. But if you adopt under the RAA, then the legal document you get will be the certificate of adoption, which will show that you have adopted the child.
Our next question is, what if the biological mother dumps the baby and she is unable to be located? How is the birth cert to be obtained?
What will happen is that the person who found the baby will need to lodge a police report, and when this matter is brought to the JKM's and JPN's attention, they will need to affirm the statutory declaration to explain where the child was dumped and whether or not there is any indication as to who the biological mother is. This is where the NRD will come in and investigate. So once they have completed their investigation, they will be able to issue a birth certificate to the child.
Moving on, the next question is, does the court need the biological mother to be present if there is a statutory declaration and the biological mother is unable to be contacted?
I would say that usually no, but I'm hesitant to say that very definitively as well, because sometimes it depends on the judge. The judge sometimes may want to ask a few more questions. So I think I had a case whereby, yes, we got an SD, and the biological mother, we say that we are unable to contact her, but the court somehow wanted the biological mother to appear, but managed to convince the judge otherwise. But so that's why I say usually yes, but depending on how strict a judge would be.
The next question, have there been any changes to how the courts have treated citizenship cases for adopted children over the recent changes in government?
I would say no. The position that we have right now is that if the adopted child's biological parents are unknown, or especially if the adopted child's parents are non-citizens of Malaysia, the short answer to whether the child can get citizenship or not is no.
The next question from Bruno. He would like to know whether a biological father can adopt an illegitimate child to grant him Malaysian citizenship.
Okay, thanks, Bruno. Good question. Well, I think there are maybe two ways to answer this. So, number one, yes, a biological father can adopt his illegitimate child. So that is allowed under the Adoption Act. But subsequently, whether it grants the child Malaysian citizenship after the child is granted, again, that depends on who the biological mother of the child is. So another way to, if I may suggest, to get Malaysian citizenship for the child is if the biological father is in good terms and intends to spend his life with the biological mother, then it's better for them to get married and legitimize the child's birth under a different act called the Legitimacy Act. And through that method, there will be a much more stronger chance to get Malaysian citizenship based on the current laws, as opposed to merely adopting the child.
Thanks for the answer, Eric. So the next question is, can a child with a red birth certificate be admitted in Malaysian schools, or can we take Malaysian IC in the future?
Okay, there are two parts to this question here. First part, as to whether the child with a red birth certificate, meaning the child is a non-citizen, whether they can be admitted into government school. Yes, they can. But what the parents will need to do is to register the child at the Ministry of Education. They will need to make a payment of 120 per year for primary school and 240 ringgit per year for secondary school, and this will be made to the Ministry of Education. Once that payment is made, they will issue you a student pass, and then the child will be able to be enrolled in the government school for education. And as to whether the child can apply and obtain a Malaysian IC or not, this is linked to the child's citizenship status. Short answer is no. If the child is a non-citizen, there will be a different process altogether to apply for Malaysian citizenship. But if the child is subsequently registered as a Malaysian citizen, then the child will be automatically issued with a Malaysian IC.
Moving on, our next question. Can the certificate of adoption be used as a legal document to apply for residency in other countries?
Actually, this is quite a difficult question. I'm not sure. My understanding would be that it depends on the laws of the other country, whether they accept this kind of document as proof. Because as opposed to an adoption, under the Adoption Act, you do not get a court order. So, and you do not get a new birth certificate. And from what I understand is that certain countries, they are more willing to accept an adoption or rather recognize an adoption in another country if there is a court order. So they more likely to respect a court order as opposed to a certificate of adoption which is issued by the JPN and is not a court order. So long story short means it depends on the laws of the other country.
Thank you, Eric. The next question. In cases of an illegitimate child, can the biological father adopt the child without the consent of the biological mother?
Short answer is no, because you definitely need the consent of the biological mother, unless you can show evidence that the biological mother is unfit to raise and care for the child, or that she is not present in the child's life. Then the biological father can apply to dispense with the consent of the biological mother in court.
The next question. In most cases, dumb babies are deemed stateless. What is the process to obtain official citizenship for such a child?
Okay, well, the government will tell you to go and apply to JPN under 15A to obtain citizenship for such a child, because their stance is that they should decide who gets citizenship for children, for such a child. But we, of course, we also try to go through the court process to get citizenship for such a child, because let's say, for example, if the so-called dumb baby is adopted by Malaysian citizens, our stance has always been that the child should be a Malaysian based on the fact that he or she has been adopted by Malaysian citizens. But so far, the courts have been not too keen to grant that based on that ground. The other ground that we tried was that because if a child is born in Malaysia and not had a citizenship of another country within 1 year of his or her birth, he or she should also be a Malaysian citizen. And that as well has not been finally decided by the courts on whether that ground is available for the granting of citizenship to stateless babies. But so either go to court or the government's method, which is you go to JPN to apply for citizenship under 15A. But that itself also will take quite a lengthy period from how our experience is.
As we are now running short on time, we will end this Q&A session with the next two questions. So Anne has a question. On your recent case of a Sarawatian teenage boy's bid for citizenship, can you talk about the court's reasoning for this outcome and what's the next steps?
Okay, thanks, Anne. I think I can take that question. Since thanks for paying attention to our cases. So, well, we tried to obtain citizenship for that our client because, number one, under the Sarawak Adoption Ordinance, which is a little different from the Adoption Act in Peninsula, it says that once a child is adopted, the rights of the child is deemed to be born in lawful wedlock in the adoptive parents. So meaning they are like taken as born to the adoptive parents. So our understanding is that that means when you try to determine who the adoptive parent's child is for the purposes of Malaysian citizenship, the child is the adoptive child would be a child for the purposes of citizenship, because the Sarawak Adoption Ordinance has said that it deems a child after adoption to be born in lawful wedlock to his or her adoptive parents. So we tried to run an argument, but unfortunately the court did not agree. So it's on appeal now. So we'll see what the court will appeal. And indeed, the federal court, if it goes there, decide. Another ground, as I mentioned earlier, is we say that the child was born in Malaysia and not born a citizen of another country, then the child is also a Malaysian. But again, the court did not agree with our reasoning. And I think the court maybe wanted us to show more proof as to we have tried to locate the biological parents of the child to determine whether especially the biological mother, whether she is actually a citizen of another country or not. So we have made some attempts on behalf of our client, whereby we try to locate the hospital where the child was born and get his birth records there, but we are unable to find any. We have also made the advertisements, but no response. But unfortunately, the court still think that is not sufficient for purposes of citizenship. But anyway, we'll we are appealing on all those grounds, and we'll see, hopeful that we'll get a better, more favorable decision in Court of Appeal and Federal Court.
Thank you, Eric, for sharing. Our next question. Can I start the adoption process as soon as the baby is born?
Yes, you definitely can. What you need to do is to get the biological mother to sign the statutory declaration agreeing to the adoption of the child. Once you have that, and you get ready with all the adoption papers, and you can get it filed in court, and the process will begin.
Thanks, Jasmine. And for our final question, can I change the name of my adopted child?
Yes, you can. This would be one of your prayers in the adoption application as well. So what usually parents would do is to change the name given by the biological parents, and they would follow the surname of the adoptive parents. But yes, such a change of name can be done during the adoption process in court.
And that's the end of our Q&A session for today. Thank you, Eric and Jasmine, for your insights. Before I conclude, we have a few announcements to make. Please join us for our upcoming talks. On the 20th of November, our Miss Anis and Mr. Wong will speak on immigration-related offences in Malaysia. You can sign up by scanning the QR code or visiting our website at mawengkwai.com. Please fill in our feedback form and let us know what you thought of our talk. The link to the form will be posted in the chat box. Please also follow or like our social media accounts. And if you would like to speak to our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website, and the link is also posted in the chat. Thank you, everybody. We hope you have found today's session informative and useful. We hope to see you at our next talk. Stay safe, practice physical distancing, and have a great day.
Thank you, everyone.
Thank you very much.